I think we can get started. We're almost on time, almost. On behalf of the University of Brescia, welcome everyone to this annual conference of the Italian Association of Law and Economics. Massimiliano Granieri from the University of Brescia and member of the SIDE Board of Directors. I shall convey to you the greetings of the University of Brescia, also on behalf of our rector, who was supposed to be here. This is the week before Christmas, so there are many celebrations, Senate board members everywhere. He couldn't make it. I'll do the housekeeping here and then leave the floor to the speakers. All the main sessions, the plenary sessions, will be here in the Aula Magna San Faustino. All the food, beverage will be downstairs, ground floor. As you enter the building on the left, there is a small area, and we will have lunch and coffee breaks and the cocktail, the welcome cocktail tonight here. There is a network, open network. You might need the password, and I will circulate the password for those of you who are not in EduRom. And for any other questions, just don't hesitate to ask me if there is something I can help you with. Just let me say that I'm extremely grateful for the number of submissions that we received. It was a little bit tricky from the logistics sides to have a number of rooms ready for parallel sessions, but when I see many people joining, it seems like law and economics is still alive and kicking, and there is a long way ahead for everyone. So thank you for joining us, and I think we can get started. Thank you again. Massimiliano.
Okay. In any case. Okay, thank you. So a welcome from me. I am Massimiliano Vatiero, the Secretary of the Italian Society of Law and Economics, maybe my last year as Secretary of this conference, this association. I am very happy to chair this inaugural session. This is a roundtable on Posner book, Economic Analysis of Law. As you know, okay, so this roundtable is on Posner's book, Economic Analysis of Law. As you know, this year marks the 50th anniversary of the first edition of this book. I wanted to show you a figure, but doesn't matter. In any case, Posner's book is the most quoted textbook of law and economics. With Professor Ben Schaffer, we wrote an introduction for the special issue of the History of Economic Ideas for celebrating this anniversary. Wanted to show you the cover, but next time. In any case, my role is very simple, so I want just to submit, to ask to our speakers two questions. We know that Posner's book has had a deep and wide influence on the birth and development of law and economics approach, and not only on law and economics approach. Therefore, the first question I would like to ask you to indicate an area of research or teaching in which this book has had a positive impact or will have a positive impact for the evolution of law and economics. The second question I would like to ask you for an area of research and teaching in which that book has had a negative impact or will have a negative impact for the development of law and economics. So I will follow an alphabetical order and start with Alain Marciano on my left, and then at the end of these 4 talks, very brief talks, 10 minutes for each one, there will be time to open the floor for a debate. So thank you. You want to close?
Thank you for organizing the roundtable, and thank you for asking me to participate in this roundtable and to ask me to answer these 2 rather tricky questions, for which I'm not sure I have answers. So it's so I don't really have an answer in terms of area. So the question is there an area on which Posner's books or Posner's work had a positive impact, or an area on which the book has a negative impact? I would say that rather than an area, the book has a positive impact and a negative impact. So I think I would answer the 2 questions in the same, with the same answer, is that it had an impact on the field itself. So I don't think that I wouldn't say that the book has a positive impact on a specific area, because the book has an impact on the field. And to me, I don't think that the book had an impact on this aspect of law and economics, or that aspect, this area, or that area. So the book is important for one reason. For me, the book is important for one reason, is that it created something, it created a field. Or more precisely, Posner gave a name. I would say something, maybe it's a kind of joke, but the most important thing of the book is its title, in the sense that with the title, Posner invented, or he gave a name to something that already existed. So there were already economic analysis of law. I would say that my interpretation is that since Calabresi and since the paper by Calabresi from 1961, there existed economic analysis of law, economic analysis of the legal system, but no one knew that. Law and economics existed, and as the name law and economics shows it, and the people who invented, who chose this name, explicitly said that they chose law and economics because they didn't really know how to name this new field. So when they invented the Journal of Law and Economics, they chose this name because they didn't really know what was this new field. So law and economics existed, and economic analysis of law existed, but no one gave a name to this type of research. So what Posner did with his book is to invent something that did not really exist, or existed, but without people being conscious of it. So he gave the field a name, economic analysis of law, a new name, and a name that was much more specific than the previous one. And giving a name to the field, he created a field. He created a new way of looking at law from an economic perspective. Law and economics, something that is different from an economic analysis of law. And Posner did that to transform law and economics into an economic analysis of law. So what the book did was to create that, to do that, was the triggering moment because Posner was really the one who made this move. And the interesting thing also from an historical perspective is that I think that Posner was not really aware that he was doing that. In the sense that when you look at the book, the first edition of the book, it's more something like standard law in economics that was done in the previous years than an economic analysis of law as Posner will do after that and others will do after the beginning of the 1970s. So using economics to analyze the legal system, an economic analysis of law, is something that is almost not present in the book. Most of the book is based on standard law in economics, antitrust, something which is very, very standard. So Posner was not really aware that he was doing something new. He adopted a new definition of economics. He adopted a new view of economics that was close to what Gary Becker was saying. But at the same time, the book does not evidence that Posner was doing something new and wanting to do something new and different. And actually, I interviewed him once, I mean, many times, but once he told me that, I don't know if it's true, he told me that. He told me that it was not him who chose the title of the book. The title of the book, Economic Analysis of Law. So I don't know if it's true, but at least it gives, it's an additional evidence to my claim. So I like it. The idea that Posner was not really, was not really conscious that he was transforming the field into something different. The title, Economic Analysis of Law, which was chosen by someone from the marketing department of the Harvard University Press, because he wanted so. And it was a good idea because the title gave the name of a field of research. So I would say, yes, I'm going to finish here. So at the same time, so my point is this one. So the book was not important for a specific area. So the positive impact of the book or the negative impact of the book is not on a specific area in law and economics, but the positive and at the same time negative because it radically transformed law and economics into something different. The positive and the negative impact of Posner's book was to change law and economics into something totally new and different. My answer.
Great. Thank you. Thank you. So the next in an alphabetical order is Roberto Pardolesi.
The second movement is equally, but for which means two minutes. When the message is there.
Thank you, Professor Pardolesi. So the next Professor Porrini.
Yes, I'm between Pardolesi shuffles. When Massimiliano asked me to intervene in this roundtable, I start from the very beginning because this is a kind of birthday, the 50th birthday of the book. So I tried to have a look to the book at the time that it was born, because what we are doing mainly it's to see at this book other kind of contribution with the eyes of the contemporaneity, our age. But I tried to be neutral, as I wasn't like Roberto Pardolesi there, but I tried to be there and to see the effects of this book on the on the legal scholars and on the generally on the people that have this book for the first time in their hands. And I also read some review of this year, of the year of 73 and 74, to see what reviewer wrote on this book. There were many reviewers, of course, that wrote about it on a law journal. And I'm grateful to Massimiliano because he makes me change idea about this book. Because doing this exercise, I discovered that this was a very big pedagogical effort. I didn't understand it before I prepared this my contribution on this roundtable. That Posner was trying to apply economic analysis of many fields of law. So we mainly focus on the fact that he used economic analysis. But what I discovered is that it was really enlarging very much the law that he was analyzing. So this book is divided in 5 parts. It has an introductory part and 5 parts. The first part is entitled Common Law. And in this part, that is only one part of the book. Yes, but it's all is in it because it is about property, contracts, torts, criminal law. So everything is in the first part. But then there are many other fields that he was analyzing that are public regulation of the market, regulation of business organization in financial market, very modern. Then there is also law and distribution of income and wealth. So the fourth part is about distribution. So many critics that are addressed to Posner say that he didn't care about distributive aspects, but there is a part especially devoted to this. And the fifth part is constitution and federal system. And the sixth part is legal process, so the procedure. So I don't know if you already know it, but I discovered that his effort was so big to cover all this part. So I don't know even if you are have never been in charge to teach law in economics. I was asked to teach law in economics, and the main problem is, first of all, to give the economic, the first lesson are devoted to give economic elements. He didn't do it. There is no chapter about economics, principle of economics. What Posner did is to use a simple economic concept without caring about explaining them before. So I think my opinion is that his idea was this is a textbook for legal students. And legal students normally have economic course, so they don't need me to teach them economics. But what I'm doing is to use some concept to analyze law, all the fields of law, like an economist. Using only 5 concepts in the introduction, he said law demand, opportunity cost, market as voluntary exchange, economic efficiency, and allocation of scarce resources. So these 5 concepts do not need to be explained with models or are just concepts, and he used to analyze these many fields of law. So in the introduction, he said that his book is for students and teachers. And also with a kind of sarcastic comment, say that teachers do not have a good grounding in the subject. So the book is pedagogical, not only to students, but to teachers. So in my opinion, with this book, Posner would like to educate a generation of legal scholars to use economic analysis. And this is why it is positive. This is why this approach to economics is positive, because it serves as a method, methodologically to address the interpretation of law. But this is not the only, in my opinion, the fact of educate, of make the new legal scholars using the economic analysis was, of course, a kind of idea to change, to reform the legal system. That's why he was addressing so many fields. It's not only a message for the future judge or for the future lawyer, but it's also to change the legal system, and maybe not only the legal system, but the society. So till now, I was telling you only a very positive interpretation of the positiveness of Posner. So I really appreciate this my second reading of the book of Posner, this pedagogical idea. Maybe because also teaching law in economics, it is clear that it's very difficult to do it. So I really appreciate his, in a way, challenging idea. Also, I think that also people that do not like particularly Posner has to admit that this is a very big effort that he made. So after his book, things changes in the field. I'm not saying that we are all we have a debt with Posner, but we are here as a law and economics researcher, and this is came also from this book that was very influential. So Massimiliano asked me also to say something negative. So 1 minute, just 1 minute negative. The negativity comes from the same, what I said now, because the idea to change, to reform the legal system, of course, is ideologically. It has ideological implication. So he has an idea, a strong also political idea. We cannot say that this is not true. And so he's, of course, a person that has a very strong belief, and this love for the market, let's say in a simple word, is very permeating his work, also his pedagogical message. So the pedagogical message is not neutral, it's very much ideological and political. But this is okay. I mean, everyone that wrote a book put in the book his own ideology. We don't have a neutral book. But the problem is that then this is remain attached to the economic analysis of law. The problem is that because this book was so influential, so spread everywhere, then economic analysis of law becomes very much linked with this ideology. So it happens to me that when I speak about economic analysis of law, people think that I'm a market supporter and that I have the same ideology of Posner. But this is not. It may exist. It must exist also an economic analysis of law that is not Posnerian.
Thank you, Donatella. So the next is Bernd Schaffer.
We have already heard so many wise comments. Difficult for something, but I agree, especially with those who have stressed that without this book of Richard Posner, it would have been much more difficult at all for the economic analysis to establish as a discipline on its own. Now, if we look at the founding fathers of law and economics, Gary Becker, Ronald Coase, and Guido Calabresi, then I think it is fair to say that their writings are deeper in a way than what Posner has written. There is no Posner theorem or something like that, there's a Coase theorem, and Posner did not arrive at completely new insights, for instance, on discrimination. For instance, the proposition that discrimination does not only inflict damages those who are discriminated, but also to those who are discriminating. That was totally unknown before him when this was completely in the hands of sociologists and political scientists at the time. And Guido Calabresi is, what he writes is, for me, politically more, let's say, more sympathy, Calabresi than with Posner. Some tendencies, political tendencies, but Calabresi does not write much on, does not use legal terms when he writes. So all his very important writings use terms which are not directly legal, like cheapest cost avoider is not a legal term, or property rule is also not a legal versus liability. All these influential things are not directly related to. And what Richard Posner has done is something very different. He took, as you have shown, he took, let's say, a book law a book on regulatory law, on constitutional law, on procedure. And then he took all these terms, these little terms, and gave it an economic interpretation. And something very difficult, that he looked at the whole body of law and what the lawyers had created, the terms the lawyers, the concepts the lawyers had created. He imposed his own ideas on it. That is an economic idea, the idea of efficiency. And he has shown that this is possible. So if he was 33 years old, I hope this now, assume you are 33 years old, you write your PhD, and you sit down and you have a book on common law and a book on microeconomics, bring these things together. That was, and when the book came out, it was a big bang everywhere. I was a young professor when it was a year old. 75, I went to Hamburg, and then I came into touch, and everybody spoke of this, even though this book is from a European perspective, topics are completely, they are all related to states, to US law. No mentioning of European or international law or something like that. So it's a purely provincial book. Still, it was like a fanfare. It regarded by all lawyers as a fanfare. Most rejected it flatly, but everybody talked about it. And I want to quote the first sentence of the first edition. As later changed it a little bit. So I have written it down. So the first sentence reads, this book shows how the discipline of law can become international and science-based. Oh no, that's not what he wrote. He wrote that this book is
written in the conviction that economics is a powerful tool for analyzing a broad range of questions, legal interpretation and policy.
Yes, legal interpretation and policy. So he said, this is a book about law as a science. It is not a book about law as, you know, knowing much about everything, but a scientific approach to law. And that was what many lawyers were looking for in the 1970s, because they said, we must move away, at least partly, from pure doctrinalism, and we have to look at the consequences of legal norms. And we have to have a better understanding of the consequences of legal norms. And that is not only an achievement for economics or social sciences, a direct achievement for the interpretation of the law, and that he has achieved. And I just give you the example of the learned hand formula of negligence, which you all know. This formula was known. Judgment of learned hand is from 1947. And Posner's article on the theory of negligence is from 1970. In the meantime is 23 years. But this learned hand criterion was used by the Supreme Court as a kind of guiding principle. But nobody, neither learned hand nor the judges of the Supreme Court who used this, nor any person who dealt with tort law or with negligence in the United States or internationally had ever realized that this is a cost benefit. Because Posner said this is an economic concept of welfare economics in the sense of caloric efficiency. Nobody had ever seen this. My colleague in Hamburg, Hein Kötz, who wrote a well-known book, I think a well-known book in Italy, he wrote, of course, about negligence in comparative perspective. He has also not seen. didn't you see it? Yeah, I said, I didn't mention this because I just said that reasonable, what a reasonable man does, but this is much more specific than just reasonable. So this concept has become worldwide. Everybody knows it. Everybody who deals with law, with negligence, must know this. There is not a single law scholar anymore in the whole world who does not know this. And when he writes a book on tort law, it will certainly be in the book, in the affirmative or critical. But this is what Posner has achieved, that he reinterpreted legal terms, purely legal terms, in economic theory, and thus created a new science. What the others did not know, purely from a point of deepness, I would say that, for instance, was more deep than Posner, but still by making this tour de force through all parts of the law, he created a new science. That, I think that is his achievement, and that makes his appearance on the field. So now the negative. Sorry. I agree fully with what you said about other legal, ethical principles. So, for instance, what I really criticize is in his early writings. Later on, he wrote about fundamental human rights. And he said, well, the fundamental human rights are also subject to cost benefit. So if you have two fundamental rights, you have to weigh, and here the weighing is simply utilitarian or cost benefit. And that is, of course, totally wrong. I think it's wrong because they have their own, they live in a different sphere, and sometimes they are placed categorically higher than that. So that is one thing I would criticize. Another thing is, Posner is, I think he is not a market fundamentalist, coming to the ideological aspect. He is not a market fundamentalist in the sense of Hayek and Mises, the libertarians, who say everything what the market does is better than everything the state or everybody can do. That is not Posner's view. But he is very critical, and he joins this with the Chicago School to the performance of the state. He says that whenever a law is made by parliament, by the state, it is distorted by special interests, governments are captured, and so on. So he's very critical about this. And then he says, but we have all these market failures, high transaction costs. Who can fix this? He doesn't say it must not be fixed. He said it should be fixed, but by the courts, by common law courts, because the judges cannot. They are independent and so on, and they work in a way, let's say, not centralized, so they cannot be captured. And this is, in my personal view, the most weakest part. I agree even with him that judges cannot easily be captured. But judges, the ruling opinion of judges can be self-enforcing as an ideology. There are many historical instances. If tomorrow a lecture, and I will give some examples, how let's say the leading judges or the lawyers in a country, society, can be streamlined. And Schleifer has criticized this in a very interesting paper, Journal of Economic Literature, the rise of the regulatory state. And he said that with the rise of the big enterprise, of big firms and big business in the United States after the Civil War, we had problems of labor relations, insecurity of workers, health problems, insecurity of some and so on. These social problems were not solved by the courts. And that, he said, led to political activism that fired political activism, and political activism then tried to change the laws, not the jurisdiction. And he said that you can see that simply the courts were not able to cope with these problems. And that was not because captured by very much ideology. And I think that is perhaps, in my view, that is one of the points. But I praise him. I think that without him, our discipline would not exist in the same way it does.
So, thanks. We have 2 minutes.